is the QC, Geoffrey Robertson. And Mr. Robertson, thank you very much indeed for being with us. What do you expect, first of all, is going to happen in the High Court this afternoon when the Sun takes its case?
Well, you can never predict because you don't know the facts. I would have thought that there is certainly a strong argument that if the Prime Minister knows the name, then so should the people he governs. But on the other hand, this has been a rather puerile exercise by the media, perhaps in judicial eyes. The newspaper in Scotland has shown him, but hasn't actually named him, and it's on that sort of distinction that hours of legal time can be spent, Adam. So we can't predict, but it does come to the point, and I think the Prime Minister's words were very emphatic, that it's time that these super-injunctions are becoming unsustainable. It's wrong to allow the privacy of promiscuous footballers to turn the law into an ass. As Mr. Bumble once said, we're almost going back to those days, and we have to get really it's up to Parliament to come down with a sensible privacy law. There are sensible models, and they should choose one.
Just on the question of injunctions, as I understand it, the footballer in question has not only been named or has his face shown on the newspaper. A prominent journalist, Giles Corran of The Times, has tweeted with his name, apparently. As have many others. And so in that case, as you say, the law is already looking like an ass, isn't it?
It is. On the other hand, you feel some sympathy for the footballer. He's been gone to court and got an injunction and got an expectation that the law will protect his privacy. That expectation should have been appealed. We've yet, and this was a point that the Master of the Rolls made in his report last week. The press, the media haven't got together. They're so cutthroat and competitive. They haven't had the sense to get together and take this to the highest court, the Supreme Court. So it's a bit rough on the footballer if tomorrow the whole world, quite apart from that part of the world that can use Twitter, finds out his name. We have a rule of law problem here that has to be solved, and if the courts can't solve it, and if the case hasn't gone to the Supreme Court, then it's down to Parliament.
What about
there's a very simple way to solve it.
What about the question of jurisdictions? Because we've heard both from the Scottish Sunday Herald and quite strongly from the Scottish First Minister this morning that he simply feels that the sort of injunctions that have been secured don't apply in Scotland because it has a separate legal system. Is there any truth in that?
Well, they can be registered in Scotland, and some injunctions are UK-wide, and it's even more difficult with Twitter, who are based in California. So that's a complex question of whether you can drag into the courts of England people who, for their free speech, as it were, in semi-independent Scotland or in totally independent America, which is passing laws against English judges. It's now got free speech acts that make it impossible to enforce the judgments that are coming out of the British High Court on free speech matters because they're antipathetic to the First Amendment. The First Amendment enables all American papers to publish without what is called prior restraint. And that, I think, is what we must now adopt. We must have a clearly defined privacy law, because this whole problem has come about because of the European Article 8, which says the courts must show respect for privacy. But in showing respect, they've gone far too far, and they've turned over the open justice principle, which is the greatest boast of British justice, that justice must be seen to be done, and they've affected free speech.
I mean,
so the best answer, I think, is to abolish all this prior restraint, all these privacy injunctions, but create a civil wrong of invading people's privacy, of publishing intimate personal details without public interest, and allow the jury. The jury is that that we look to as representative of the public to give what is considered to be a current moral view of
the reality
tabloid
is
press
that
behaviour.
the sex lives of TV stars and sporting stars and things. I mean, there's no doubt that people are interested in reading that in their newspapers. And are you saying that you feel that simply revealing that so-and-so's had an affair with so-and-so should be suppressed, that there shouldn't be a right to report that sort of stuff?
No, what I'm saying is that I'd like the Duke of Wellington, when a newspaper reporter asked him about his mistress and threatened to publish, he said, "Publish and be damned." So let the newspapers publish what they think they can get away with, and then if you as the victim are outraged by the invasion of your privacy, you can take the newspaper to court before a jury, and a jury can award damages if it thinks that the newspaper has behaved immorally by invading your privacy. And I think after a few cases the press will get an idea of what the public regards as proper behaviour and what the sort of behaviour it's prepared to condemn. I mean, it would have been very interesting to have a jury verdict on the Max Mosley case, wouldn't it? We had a judge who said it was a £60,000 worth invasion of privacy. A jury might have thought that having sex with 5 women at a time in a kind of spanking environment was in the public interest to expose. I don't know. But that's a matter that, it seems to me, a decision that should be made by the jury, and if it had awarded £600,000 damages, you can be damn sure that the News of the World wouldn't do it again.
It sounds
But
like,
on the other hand,
it does sound like you've got a fairly sensible solution. Do you think that this is the direction in which the government is moving, that the Justice Secretary this afternoon might say?
I don't think that Mr. Hunt has a clue. I mean, he doesn't seem to be able to get to grips with it. We're going to hear from Ken Clarke, who's a sensible minister on subjects certainly other than rape, and he's an old jury practitioner himself in the Crown Court at Nottingham, and I think he'll have hopefully have a better sense of what the law can and cannot do. What the law can't continue to do is to act like King Canute and to keep this wild sea of information on the internet at bay. We've got to, the judges will be unhappy, clearly, that the people have got around their rulings, but we've got to go back and consider from first instance the law, and it may be very much in our historic traditions. Go back to Blackstone, the great jurist, who said there should be no prior restraint. The press, and this was in 1727, the press should publish and be damned so long as damnation comes after publication. So I think that let's have a clear privacy law that defines privacy, intimate personal details, defines the public interest that justifies breaching privacy, exposing crime and wrongdoing, exposing hypocrisy, exposing government waste and mismanagement, clearly defined so the press know where they are, and then let victims, if they think they've been wronged, sue for very heavy damages. But whatever you do, don't rely on the Press Complaints Commission, which is a kind of confidence trick that no longer inspires confidence. It doesn't do anything for the victim, and of course it was set up originally as the Press Council by the press proprietors in order to forestall the advent of a privacy law. Well, we now have a privacy law. That's a good thing, but it's a bad privacy law, so let's get a better one.
And at one level, this is coming down to an almost classic confrontation between the elected legislature and the judges, the legal system, isn't it? When you've got someone...
It's sad because...
Justice
I've been
Nordberger
involved,
saying that the parliamentary privilege should be reconsidered.
Yes, that's clearly wrong. I think he didn't have the up-to-date information about decisions in other countries. He said it was an open question. I think it's a very careful, clearly closed question. I mean, we had this debate. I was acting for Duncan Campbell. He was the C in the ABC case. And you remember there was a Colonel B who was said to be so utterly secret that no one other than the court should know his name. And in fact, his name was plastered over every regimental magazine, every magazine that was in every self-respecting KGB library, and it was obviously ridiculous. But the press couldn't publish his name, and a couple of the NUJ journalists wrote his name in the sand at their annual convention at Whitby, and the police were called, the special branch rushed to the beach, and the tide had just come in and washed over the name. And that was when 4 MPs, including, bizarrely, perhaps Robert Kilroy Silk, when a young Labour MP, when the Speaker was dozing off, named him, and the DPP and the Attorney General went mad and they threatened the press. This is in 1977, with prosecution for contempt, and the press all took advice, and the next day they all published the name. And I think since then it's been very clear that if you reveal something that MPs and Lords can, they have complete immunity when they reveal it, and the press does have immunity when they publish. After all, it would be ridiculous. You could only prosecute newspapers because broadcasters, the proceedings are broadcast, and the name comes out simultaneously as soon as it's produced.
Okay, so Geoffrey Robinson, we're going to have to leave it there. Thank you very much indeed. Be interesting